So welcome everyone to tonight's constitutional conversation with my colleague, Stanford Law Professor Bernadette Meyler, who's going to be talking to us about the pardon power and based upon her new book. It's just been out, what, a couple months? Is that right, Bernie?
It's actually been longer, but I'm going to talk about further developments since there. It's about a year old now.
Okay,
It's
so in any
it's
event,
obsolete now.
the title of the book is Theaters of Pardoning. And this is like a lovely title to capture Bernie's combination of interests. And she teaches constitutional law, but is also an expert on the common law and on law and humanities. So the theaters of pardoning seems to bring those things together. And I, for one, am very anxious to hear what she has to say about it. And be thinking about questions. And she'll be talking for the first half of our time roughly. And then she and I will have a bit of a conversation, and during which I will parlay your questions to her. And so please put those in the chat. So Bernie, I should introduce. I just assume everybody knows Bernie. Everybody does know Bernie, but in case you don't, she is, as I said, law professor here at Stanford Law School, teaches constitutional law, 14th Amendment, various related courses. She has a PhD in English and JD from Stanford. Started, I believe, at Cornell and has been at Stanford Law School as our colleague since 2013. So welcome to Constitutional Conversations, and take it away.
Well, thank you so much, Michael, for that kind introduction. And thank you also to Morgan for organizing this. I'm really thrilled to be here, and thanks to everyone for coming. So I'm going to talk about my book, Theaters of Pardoning, but also talk about a couple of developments that I've been working on since writing the book that emerged from it. The book itself traces the arc of pardoning through 17th century England and between drama and politics, from Shakespeare's play Measure for Measure to King James I's response to the Gunpowder Plot, to politically murky plays like Philip Massinger's The Bondman, to the royalist closet dramas of Cosmo Manouche, to Thomas Hobbes's treatment of the 1660 Act of Oblivion on the restoration of Charles II to the English throne. In the process, my book argues that changes in how pardoning was figured augured alterations in the location of sovereignty from king to parliament. As one of the prime marks of sovereignty, and Michael has recently talked about prerogative powers in his recent book, pardoning was vigorously fought over as part of the contest over who would hold ultimate power. Furthermore, I argue in the book that the shared audiences and actors of drama and politics conveyed conceptions of pardoning from one sphere to the other and back again, transforming them in the process. So I first want to give you a little bit of a window into my book by explaining a bit how the idea for it arose. When I was in graduate school, I found myself simultaneously reading large swaths of early modern drama and also theories of sovereignty and the relationship between law and sovereign power. And in doing that reading, I was struck, on the one hand, by how many of the plays I encountered ended with a final pardon or set of pardons. These were tragicomedies, but slightly different from the pastoral tragicomedies that were popular in late 16th century Italy. I wondered why there seemed to be a cultural obsession with pardoning in early modern England, and why it came to be used as a generic device to make a play end happily. On the other hand, I noticed that pardoning seemed to function as a form of exercise of sovereign power in the political as well as the dramatic sphere, a form of sovereignty that many theorists like Michel Foucault ignored. This led me initially to think that the representations of pardoning might shift from more monarchical and individual to more general and legislative over the course of 17th century England, as crises in royal sovereignty came to a head. I then realized the story wasn't quite that simple, because some plays imagined the possibility of non-sovereign pardoning, pardoning divorced from a supreme power, whether monarchical or legislative, and emanating from the people not themselves conceived as sovereign. And this is something I'll come back to later in my talk. It was this democratic vision of pardoning that interested me most and made me wonder if our current skepticism about pardoning, a skepticism evidenced by the radical decline in exercises of mercy by governors and presidents over the past half century, comes from its historical association with sovereignty. This association has arguably been cemented in the US Constitution by interpretations of the president's capacity to pardon as plenary and emanating from the king's prerogative powers, a conception most fully put into practice by former President Trump. So the book tries to show the genealogy of that view as well as the roads not taken in thinking about pardoning. With the remainder of my time today, I would like to elaborate on two strands of the book that I am building upon in my current work. First, while writing Theaters of Pardoning, I came to realize that the transformation I had initially focused on neglected a significant emerging element of the 17th century English polity, which was neither king nor parliament, but instead was that of judicial reasoning. Although historical accounts of the English Revolution and the changes in government that it occasioned, both directly and indirectly, tend to concentrate on the role of parliament in limiting the inherited powers of the king, the growth of common law reasoning in the 17th century proved at least as important, I would argue. One of the most significant figures in this development was jurist Sir Edward Coke. And this is a picture of Coke on the next slide, who served as Attorney General, Chief Judge of the Court of Common Pleas and King's Bench, and Member of Parliament during the reigns of Queen Elizabeth, King James I, and King Charles I, and composed the extremely influential Institutes of the Laws of England and volumes of reports. Coke attempted to limit pardoning at the same time as limiting other prerogative powers of the king. As I write in the book, Coke cabined the capacity of the king to make law without the consent of parliament. Even more centrally, he restricted the scope of the king's judicial power. In Coke's conception of the common law, the institutions of the legal system themselves subsisted beyond the reach of the king's sovereignty, furnishing an ancient constitution that a present ruler could not alter and that undergirded the subject's rights. Rather than being opposed principally to more democratic legislative decision-making, the king's power was contrasted with the right embodied in the common law and its institutions. There are a few specific examples of what he did in the early 17th century. There were restrictions he tried to impose on allowing the king to judge in person. There were some limitations he suggested imposing on the pardon power. And then also in Bonham's case, which some have taken as a precedent for judicial review, he talked about the prohibition on judging in one's own case. So these are all limitations on the king's judicial power, if we think of pardoning as well as a kind of judicial act. And what Coke grounded this conception of the common law and this view about the common law as perhaps even more fundamental than the king's prerogative powers, he grounded it in not in Roman law, but in a more ancient law that he posited. So as I explore in the book, he claimed an alternative basis for the common law of England that would precede the Norman conquests and the power of the Norman kings. And in fact, he claimed that English common law came out of the Greek concept of the common law of the Greeks. So he quotes a phrase from a lost Euripides play, nomos koinos helados, the common law of the Greeks, as being indicative of where English common law came from. And one of the things that Coke does is to read Jean Baudin's 6 books. Oh, and this is this Polyanthea Nova is one of the places that he got some of his classical learning from. But one of the important sources for Coke and his interpretation of pardoning and other forms of prerogative powers was Jean Baudin's 6 books of the Republic. And this was really one of the first works to define the notion of sovereignty in the early modern period. As many have argued, King James I's writings on kingship and his efforts to bolster his own divine right theory of monarchy in Basilicon Doron and other works were significantly influenced by Baudin's work, which was initially published in French in 1576. The impact of the 6 books was felt in England from shortly after its publication, and James appears to have read the French version. Baudin himself traveled to England in 1581 as part of the entourage of the Duke of Anjou, who was engaged in the effort of courting Queen Elizabeth at the time. Only in 1606, though, was his masterpiece translated into English by Richard Knowles under the title of The Laws and Customs of a Commonwealth. The significance of the French version of Baudin's work to English thought about sovereignty is suggested by a Google Ngram search of Baudin and sovereignty in English between 1500 and 1700. And you can see that Baudin kind of rises around the 1560s, and then shortly thereafter is sovereignty. And then you see again the use of sovereignty in English quite prominently in the early 1600s, around the time that Baudin's work was translated. So I think you can see from that the impact of Baudin's work on English thought about sovereignty as well. While James I's debt to Baudin has long been acknowledged and has been thought of as a grounding for some of his absolutism, recent scholarship on the legal and political theory of the early 17th century has shown that his influence was a lot more widespread and potentially had a lot more different implications than previously imagined. So Daniel Lee, in Popular Sovereignty and Early Modern Constitutional Thought, traces a line from Baudin, whom he reinterprets as furnishing a theory of popular sovereignty, to parliamentarians like Henry Parker, who wrote in the lead up to the English Civil War. But Lee largely neglects the arguments of common law judges like Coke in response to notions of sovereignty derived from Baudin. In this sense, Ian Williams's article on developing a prerogative theory for the authority of chancery helpfully supplements Lee's work by illuminating the extent to which the stakes of jurisdictional debates among the courts were predicated on interpretations of and opposition to Baudin. But even Williams doesn't flesh out the full extent of Baudin's influence, though, and doesn't consider Coke as a reader of Baudin. And this is something that I copied from the archive that currently houses all of the remaining works that were in Sir Edward Coke's library, which is an archive at Holcombe Hall, which is his ancestral estate. This is a picture. It's one of the most beautiful places I've ever visited. But there are a lot of books there that he annotated in his own hand. And among the most annotated is Baudin's 6 Books of the Republic, which is annotated in the French version. And also, it's incredible. Coke annotates in all these different languages, depending on what language the book originally was written in. So some of the lessons that you can take from the annotated version of Baudin in Coke's library are a kind of interest in the relationship and distinctions between sovereignty and prerogative powers, and also an interest in how the law changes. And in particular, there's a passage that he highlights that becomes a later passage of great importance within common law theory. And this is a passage about what's thought of as the ship of the Argonauts. So in Baudin says, now the law saith that the people never dieth, but 1,000 years hence to be the same that it was before. By successive propagation, they be immortal, no otherwise than Theseus his ship, which although it were 100 times changed, by putting in of new planks, yet still retain the old name. But as a ship, if the keel be taken away, is no longer a ship, even so a commonwealth without a sovereignty of power, which uniteth in one body all the members and families of the same, is no more a commonweal, neither can by any means long endure. So here, Baudin is using this image of the ship of the Argonauts, the ship of Theseus, and saying that only with a sovereign can that ship stay the same. Now, what's noteworthy is that this later becomes an image that common law thinkers like Sir Matthew Hale later in the 17th century adopt and say that the common law is actually this ship without any sovereign power guiding it and without any sovereign power controlling it as the keel. So this is really a kind of transformation in the grounding for the state from a model of sovereign power to a model of common law power, or maybe even we might say proto-constitutionalism. So I think that Cook's reading of Baudin and then Cook's work in general fleshes out the nature and extent of common law resistance to sovereignty and its later implications for the role of constitutionalism as a check on sovereignty. So that's one strand of work that I'm pursuing now as an outgrowth of the book. The second strand involves my attempt to furnish a more democratic basis for pardoning. Although I generally describe a trajectory from royal sovereignty to parliamentary sovereignty within theaters of pardoning, some of the places I mentioned earlier suggest a greater and I think more democratic role for individual citizens within the pardon process. In particular, there's one play of uncertain authorship called The Laws of Candy, meaning Crete, not the sweet, which imagines a series of individuals and ultimately the entire Senate of Crete being condemned for violations of a law of gratitude. Here, the state is almost on the verge of collapse at the end of the play, but what happens then is that a foreigner forgives first the Senate and then a series of other individuals so that eventually the entire state is reconstituted once these individual acts of forgiveness take place. So I'm interested in taking a cue from this and other 17th century experiments in rethinking pardoning and considering what lessons they might have for reconstructing pardoning in 21st century America. Despite centuries of opportunity, arguably no prior political figure has deployed the theatrical potential of pardoning to aggrandize sovereignty with as much fanfare and commitment as former President Donald Trump. And here you see him holding up the paper of his grant of clemency. You don't see his very large signature on the bottom, but one thing that was noteworthy about Trump's pardons was that his own name is much more prominent than the name of the person being pardoned, and his signature is also very large, unlike the way in which earlier pardons were created. From the selection of those pardons to the timing of his pardons, Trump generated spectacle after spectacle designed to enhance his own image through his successive pardons. As a result, even though he issued only 143 full pardons, fewer than President Obama, and in accord with the trend of declining exercise of the presidential pardon power, Trump's pardons garnered substantial media attention and spawned widespread criticism. Calls to limit the president's power to pardon, either constitutionally or through statute, pervaded Trump's tenure in office and persist in its aftermath. These calls furnish an opportunity for the Biden administration to transform the pardon process, and in doing so, render it less a relic of a sovereign royal authority and more a liberal democratic institution. The question of how to reclaim the legitimacy of the pardon power in a liberal democracy looms large in the wake of Trump's presidency. Some recent scholars have echoed the skepticism implicit in the writings of members of the founding generation, like Thomas Jefferson, toward the very possibility of the compatibility of mercy with liberalism or democracy, and particularly with the two taken together. So, for example, Aziz Haq has observed, quote, a tension between the demands of democratic rule and merciful discretion, in addition to the, quote, tension between the demands of justice and the exercise of mercy. According to Haq's account, there are insufficient constitutionally based reasons to prioritize discretionary mercy over majoritarian will, which he takes as the core of democracy. While acknowledging that in European systems, autonomous bureaucracies may achieve the ends of mercy, Haq views recourse to these as abandoning the full spectrum of democratic control mechanisms available on other occasions. Such views might lead to despair about the possibility or even desirability of redeeming the pardon power from sovereignty. Many have, however, considered how to restore the legitimacy of pardoning today. Proposals divide roughly into three major categories: The first insisting on the necessity of constitutional amendment, the second relying on the other branches, whether Congress or the courts, to limit the unchecked discretion of the president, and the third reviving old mechanisms or creating new ones within the executive branch itself to regularize the grant of pardons. Pursuing the constitutional amendment route, Keith Whittington has suggested the necessity of a bipartisan amendment restricting issuance of pardons by a lame duck president, self-pardons and pardons of family members, as well as pre-conviction pardons. Jack Goldsmith has instead pressed for congressional action, arguing that Congress should legislate to, quote, expressly make it a crime for a president to issue a pardon as part of a bribe or as an inducement to obstruct justice, as well as to declare presidential self-pardons unconstitutional. Others, including Neil Buchanan and Lawrence Friedman, have maintained that courts should retain the authority to limit the pardon power against certain significant varieties of presidential overreach. One problem with these proposals is that they only furnish restrictions on the outer limits of presidential pardons and on types of pardons that will hopefully be few and far between under the succeeding presidents. Although earlier presidents had sometimes been accused of corruption in pardoning, as with President Clinton's 11th hour pardon of financier Mark Rich, the extremity of the change in the exercise of pardoning under Trump furnishes some assurance that his use of the power might be an anomaly. More problematic going forward than Trump's efforts to pardon family members or close associates is his use of the pardon not for the general good and for the polity as a whole, but to affirm his own power above the law. It is this lack of democratic legitimacy at the core of the decision-making about pardoning that a reform proposal should address, in my view. Judicial reinterpretation of the pardon power or a constitutional amendment might partially fix this problem by giving the amnesty power back to Congress. It was only during the late 19th century cases arising out of President Andrew Johnson's vigorous use of the pardon power to assist members of the former Confederacy and Congress's objections against it that the Supreme Court declared in United States against Klein that pardoning included amnesty and was the president's power. Earlier constitutional history suggests that that interpretation was not inevitable, and many European countries allocate the responsibility for pardons and amnesty in different actors, giving the amnesty power to a legislative body. Given this history, the Supreme Court could alter its interpretation of the president's power. Alternatively, a constitutional amendment might clearly separate the two functions. This would permit Congress to actively debate amnesties for certain categories of drug crimes or other mechanisms for remedying the problem of mass incarceration, as well as allowing for democratic input into the process. In addition, certain proposals to reform pardoning within the executive branch hold promise. Margaret Love has long advocated for reinvigorating the reliability of the administrative process of the Office of Pardon Attorney, including in the aftermath of Obama's presidency, when she lamented how closely Obama's clemency initiative had become tied to the agenda of federal prosecutors. Perhaps most recently, Rachel Barco has proposed to fix that problem by urging President Biden to move the clemency process outside of the Department of Justice and to create a clemency advisory board with bipartisan, diverse membership, charge them with evaluating clemency petitions, and consider the board's recommendations regularly. Although this recommendation would regularize pardoning and render it more compatible with a liberal system, it might not solve the problem of its democratic basis, at least not for those unconvinced that an administrative process alone possesses sufficient democratic legitimacy. One mechanism that could be incorporated into the idea of the Clemency Advisory Board and thereby integrate a more fully democratic element might be a lay component along the lines of a pardon jury. And this is a representation of the combined lay and professional tribunals that are judging cases in Japan, criminal cases in Japan now. Bringing ordinary citizens into the process through a selection mechanism similar to that of a grand jury would involve individuals directly in the process of deliberation about the justice of granting pardons in particular cases, as well as assessment of the values served by the underlying legal regimes. While citizens are involved in the decision about whether to convict or acquit accused individuals, far too few are privy to the aftermath of the criminal process and evidence of the consequences of conviction, whether in the form of prison terms or the civil disabilities subsequently imposed. integrating lay members into a clemency advisory board would further implement what Akhil Amar and others have argued was the framers' vision of juries as protective of democratic participation. The most troubling aspect, I think, of President Trump's theater of pardoning was not that it sent a variety of messages about the criminal justice system, but rather that the form and nature of those messages affirmed his own power over the law. A democratized theater of pardoning would involve the citizenry as well as experts in evaluating the effects of the criminal justice system, an exploration that would both do justice in the individual case and could motivate broader systemic reform. So these are some of the angles of research that I'm pursuing in the wake of my book project, and I really look forward to hearing your questions and comments. So with that, I'll open it up.
So thank you very much, Bernie. That was fascinating. Can I begin by asking for you to share a little bit more historical background? You refer quite frequently to Mr. Trump's pardons, and that will become history, but not yet. So most of us, I suspect, remember a lot about that, but many of us have forgotten much what's become before. Bill Clinton's pardons, you mentioned Mark Rich, but as I remember, there was a whole passel of questionable pardons. I wonder if you could tell us about that. And also, are these rare, or in American history, have we had one series of questionable, corrupt, irrational pardons after another? Or are these two presidents unusual?
Yeah, so I think it's a great question. There certainly have been suspicious pardons at different moments in American history. I would say the 20th and 21st century up to Trump have been kind of less prominent in terms of the nature of the pardons and in terms of the number of suspicious pardons being issued. In particular, there's been a kind of decline in pardoning generally. I would say that the real source of a lot of kind of infamy around pardoning is really Johnson and the aftermath of the Civil War, where what happened was that Lincoln had agreed with Congress that there would be some amnesties. Then he's assassinated, and then Johnson taking over starts a kind of two-part pardon process where he has wealthy members of the former Confederacy lobbying. There's a great set of work being done by Cynthia Nicoletti at Virginia about actually the lawyer involved in lobbying for a lot of these people who was just camped out at Johnson's office every day. And that he kind of issued these wholesale pardons, and Congress eventually decided that they didn't want to grant amnesty, that there were problems with granting mass amnesty to members of the former Confederacy. And so they tried to retract that. And then after that, we get all of these battles between Congress and Johnson about who controls the pardon power, and in particular, whether Congress can actually retract its amnesty and thereby fetter Johnson's power. And that's how we get these kind of cases coming out explaining or interpreting the Constitution as granting very broad presidential power over pardoning in the late 19th century. So I think that kind of sets up a broad presidential power. It's abused off and on, but not in any particularly dramatic way. You can find newspaper articles kind of critiquing one or another kinds of exercises of pardon after that, but it's not as much of a focal point after the Johnson administration.
So Johnson, Clinton, Trump, what about all the rest? Or has the pardon power, slumbered relatively uncontroversially except during those times?
No, there have been I haven't done a comprehensive study of the 20th century pardons, but I am working on with someone who's doing a documentary on kind of the history of pardoning in the United States, and has talked about other episodes that are problematic, but I haven't myself looked into those.
And have you looked into a comparative study of this, other countries? Is this unique to the Anglo-American system, or is pardoning ubiquitous?
Yeah, so pardoning is fairly ubiquitous. I think a lot of the abuses are more within the American system. Martha Minow has done some interesting work about the kind of comparative dimensions of the of pardoning, and I think she would agree with me that most of the other systems divide pardoning from amnesty more clearly. So if you look at, historically, the French and the German constitutions have separated out pardoning and amnesty and have been quite clear that amnesty is the power of whatever the legislature is in that context. And so that's meant that the pardon power is both more limited and also often cabined by various procedural rules. So there tend to be more close limitations, either administratively or through some other process, maybe even legislative, on the exercise of the pardon power in other places. So it's not as, it hasn't been construed as absolute a power as in the United States.
And when you distinguish between pardons and amnesties, what do you mean? What is the difference?
Yeah, so amnesty generally involves a kind of wholesale, both a wholesale exempting of a group from punishment. So it could be something that's defined by people who participated in a certain set of events. All are not going to be prosecuted for something. So, impunity, or will be relieved of punishment from that. And then amnesty also sometimes involves just refraining from prosecution of a particular set of crimes. So that, it's both collective and it has a dimension where it doesn't require a kind of specific naming of the offense. So it could be a little bit more like what people were talking about in terms of sort of late in the Trump administration about preemptive pardons, right? So preemptive pardons start looking a little bit more like amnesties than traditional pardons, which would have maybe involved specifying the offense and specifying what was being pardoned.
Well, I guess one of the most famous incidents of amnesty then is Jimmy Carter's amnesty for draft evaders after the Vietnam War.
Yes, and I think that's a really interesting example, because there are huge debates in Congress about whether Congress was able to pass an amnesty for the draft evaders. And then Congress ultimately, is embroiled in controversy about this. And based on these cases that came out in the aftermath of Johnson, because they're saying, well, the president has the power of amnesty as well as pardon, so we can't issue an amnesty. And there's a whole debate about, well, do they have a concurrent power of amnesty as well? But then ultimately Carter winds up issuing the amnesty. But there are these long debates based on historical evidence and various other practices in other countries about whether Congress has that power. And frankly, I think that it would be a better power for Congress to exercise, because it has, you can get more buy-in, you can hear from constituents, you can hold hearings. It's something where you can do more generalized fact finding and then be able to issue an amnesty instead of having it, done simply by the executive.
So one of the debates over the pardon power at the Constitutional Convention, and one of the waning days, it was practically the very end of the convention, was when Edmund Randolph suggested that the pardon power not extend to treason. And the response was, actually, treason is sometimes the most important place for the pardon power. And what I think they were thinking of is that in the wake of uprisings or rebellions, which could constitute treason, that the ability of the government to offer a pardon is often a way to end the the uprising and bring about a healing, a national healing, the way President Washington did with the participants in the whiskey rebellion. But that suggests to me that it really does, those look a little bit more like amnesties, right? And it suggests to me that maybe it does make sense for this to be presidential rather than congressional, because only the executive can do the kind of the offer and acceptance of this, because the important thing is for somebody to be able to give a promise of pardon if you lay down your arms.
Yeah, so certainly the Whiskey Rebellion, I think, fits the description of an amnesty. I would argue that at the time of the convention, there's ambiguity about whether pardoning is supposed to include amnesty or not. And that basically, yes, that pardoning treason, it might suggest you want to be, and then also Hamilton makes statements about kind of needing to intervene in a crisis, right? That you might want to pardon rebels the way that Washington does in the Whiskey Rebellion. I mean, I think they also probably have in mind the model of kind of an individual traitor, who's maybe leading a group being pardoned, right? So that once you've pardoned that one figurehead, maybe you're sort of extending an olive branch. I think that's more like a traditional pardon, right? So I think that you can interpret it either way when you're thinking about treason, especially because with treason, the constitutional requirement is that you have to have two witnesses in open court, right? So it's not necessarily the case that you're really going to be able to prosecute most of the kind of accomplices to something like the Whiskey Rebellion for treason. You may only be able to really successfully prosecute a leader. And that might be, I think that the symbolism of kind of pardoning the leader might be what they had in mind also. And if I think about, there are some examples also from other countries' contexts, like, for example, there's some examples of a Chinese emperor kind of using the pardon power very dramatically to spare the life of someone who had tried to assassinate him. And it's in order to kind of bring the whole constituency of those who were opposed to the emperor back into the fold. So I think that you could see it either way, but certainly that idea of pardoning as a technique for reconciliation does resemble amnesty to some extent, and it has, features in common with it.
So a question from a member of the audience is, the question is this: regardless of the royal history, is there any broad modern social good that's served by presidential or gubernatorial pardoning?
Yeah, I mean, so I think that that's a really important question. I think my view is that the way that it's currently formulated is somewhat broken. So I think that we're not serving the goods that we could by the pardon power. Some people would say, well, and this would be following kind of Thomas Jefferson, once you have a relatively reformed criminal justice system, you actually don't need pardoning anymore because we've gotten rid of all of the extreme punishments that were imposed, for minor offenses, which justified pardoning in certain cases. And we don't really need it in other cases. So there's really no actual need for the pardon process. I think that pardoning affords an opportunity to kind of review the success or failures of the criminal justice system after the fact, and that it allows us to think about whether communally and as a society, whether it's justified for people to experience certain kinds of punishments that they are undergoing. I think there, even though we don't have the death penalty for the vast number of offenses that were the case in early modern England, there are ways in which our criminal justice system is disproportionate and punishes people in ways that we might have societal objections to. And I think that the pardon process and the grant of pardon can highlight that and also help to remedy some of those injustices, so that if we had an ideally just criminal justice system, maybe pardoning wouldn't be necessary. I think I would reserve the instances where it is helpful for societal reconciliation along the lines that you were suggesting before, Michael. But I think in the run-of-the-mill criminal justice context, it might not be as necessary if we had an ideal criminal justice system. But I think that we're far from accomplishing that, and so there is still a role for pardoning.
Well, I don't think we have to worry about the ideal criminal justice system coming in and preempting your book anytime soon. One sort of classic example of pardons is when the governor, it's usually, I think this is more common at the gubernatorial level maybe than the presidential level, but this is where an actual innocence claim is made and the governor cuts through all the red tape and just lets the person free because they're convinced that it was a wrongful conviction. And this is especially important, perhaps, given how intricate and difficult we have made it to raise actual innocence claims through the habeas process. But I wonder, so this is a classic example, but does it happen very often? Or is this just sort of the myth that keeps the pardon power going?
Yeah, I mean, so I think that governors are increasingly hesitant to use their pardon powers. I mean, we've seen some interestingly broad uses of pardoning, for example, in Virginia a few years ago, where at least the clemency process was kind of used to, in a broader way, to remedy injustices in the nature of people's sentences and terms. I don't know exactly how many, like what number of actual innocence claims are brought before governors, but I think certainly the statistics show that governors are increasingly reluctant to use their power, and I think it's because of this perception that it's a power that's above the law. And that's I think I saw in the chat there was another maybe follow-up sort of saying, is it only for the elite that pardoning can happen, right? Or only for those who can afford a particular attorney? I mean, I think that's part of the problem with how pardoning is administered right now, that you need this wealth of kind of support and connections in order to facilitate getting a pardon. I mean, I think back to Johnson being lobbied by the attorney who was in his office every day. So that, and that is actually a longstanding part of the history of pardoning. If you look at medieval France, Natalie Zeman Davis's book, really interesting book, Fiction in the Archives, Pardon Tales and Their Tellers, it's basically about lobbying for pardons in the early modern period, and the ways in which attorneys kind of served as agents, or people served as agents for those seeking pardons. But I think that if we want to have a more just system where these claims of actual innocence can be processed regardless of, say, whether they've met their habeas requirements or not, then we need to have a better system in place. And I think someone like Margaret Love has written interestingly about, how to kind of make the administrative process more transparent and facilitate petitions being heard in a more effective way, so that it's not just the random case that can get prominence and be pardoned, but instead it can actually serve functions of justice within the criminal justice system.
Are there organizations that devote their efforts to uncovering, documenting, and bringing to the attention of the executive attractive candidates for pardoning?
That's an interesting question. I don't fully know the answer. I mean, I know it's part of, there are various private attorneys who do work in the pardon process, but I'm not sure exactly what organizations devote most resources to that. I'll have to investigate.
And an audience question: what would an appropriate procedure that would bring some equitable status to this? What would it look like?
Yeah, so I mean, I think there are a lot of proposals kind of burgeoning right now, actually, because it does seem like a moment when there might be some reform on the federal level to the pardon process. There have been some interesting efforts on the state level. So, for example, in Michigan under Jennifer Granholm, she involved citizens in a pardon commission. It was overturned at some point, or that process was changed at some point. So I'm not sure exactly whether it was perceived as unsuccessful or not. But I think having a kind of broad-based commission along the lines that also Rachel Barco has suggested, but involving, in my view, involving also lay participation and citizen participation in order to deliberate over whatever petitions were filed, I think would provide more transparency and more accountability in the process. And that they should basically receive even a short letter from a prisoner requesting a pardon, and then be able to kind of investigate that case and decide whether that was a worthy subject for pardoning. So I think that a situation where you have a more deliberative body, ideally with some participation of the citizenry in thinking about, what kinds of pardons are appropriate or desirable, would help to render the process more transparent and also more accountable.
I'm not sure I understand that, because lay participation sounds a little bit as if we're moving in the direction of a jury for pardons. And there are many virtues of a jury system. I'm not criticizing it, but transparency and accountability are not among them. Like, the jury system is meant to be a black box, and we have no idea really what went into the decisions. It's and it seems as though if transparency and accountability are your or what you're looking for, I'm not sure why that would help.
Yeah, I mean, so I'm not envisioning a purely purely a jury system for pardoning, but my view is that if you involve more people from the community, whether it's on the state level or the federal level, in the deliberations, that there can be an effort both to kind of bring insights from the community to bear on the process, but then also that those people will be able to communicate after they say serve on this, maybe they serve for 6 months on this board. After they serve on it, then they can kind of bring their insights back to the community about what they observed with respect to the criminal justice system, as well as the particular context of pardoning that they engaged in. Because, I think part of what this would do would be to allow a kind of lay participation after the fact in the criminal justice system, rather than just at the moment of conviction, right? We have lay participation when we are sending people to prison or not, but at the same time, we don't really have a moment of reflection on that collectively after someone has been serving or in the aftermath of someone's conviction.
Now, do you see reforms of this sort as being additional avenues for obtaining pardons, or do you see it as restricting the current system of sort of executive, unilateral, or arbitrary pardoning? That is, what is the purpose of the reform, to bring to widen the scope of pardoning in a rational way, or is it to narrow the scope of pardoning to prevent abuses?
It's really to widen it. I mean, I think that based on the constitutional text and the way it's been interpreted, at least, there aren't really that many plausible avenues absent a constitutional amendment for cabining the presidential pardon power. Maybe on the state level, there are more limitations, but I think if we're thinking about the federal context, other than a commitment by a particular president not to abuse the pardon power, it's very hard to kind of set definitive limits. I mean, I think that something like a pardon given in response to a bribe even though Goldsmith thinks that it has to be kind of explicitly stated by Congress that that's wrong, I think that I don't really see a court upholding that. But absent something so clearly wrong, I think it's very difficult to limit presidential pardons. So what I'm envisioning is something that would instead kind of create a more democratically legitimate basis for expanding the pardon power.
Let's return to your book for a moment. We've gotten awfully modern and awfully legalistic, right? Two law professors, no surprise. But what do we learn from? Can you give us a few of the literary examples, and what do we learn from them? About this issue?
Yeah, so one of my favorite of the literary examples is Shakespeare's play Measure for Measure, which I think is a really fascinating work because it both involves a lot of things that James I was kind of doing at the time, and it was also performed before James I. But in particular, it starts out with an old law being revived, a law against premarital sex, and then one of the protagonists is condemned for violation of that law, and then at the end he's pardoned. But what I think that play really shows is the way in which the kind of the law itself and the way in which the law is imposed has to be kind of legitimized by these final pardons, right? So that the only way that, and we're not even sure whether the law is still in effect after the end of the play or not, but that it's kind of the injustice of the law itself that winds up being highlighted by the final pardons and by the way that they're conducted. And then so that's, and then that play also has a kind of long history afterwards, where it's taken up in different guises. And another play that I think is quite fascinating that I talk about is Massinger's The Bondman. And that deals with slavery in the Roman context. But it is also about questions of kind of political freedom and republicanism. But it's an interesting play because it was performed by revolutionaries during the English Revolution. It was performed on the restoration of Charles I to the throne, and it was performed before Charles I before that. So it has this very ambiguous political valence that it could be taken up by both royalists and revolutionaries equally. And part of the reason for that, I think, is that it really is a play that where pardoning is kind of in service of the state. So it goes back to what you were talking about before, Michael, in terms of pardoning being about sort of transitional justice or reconciling the state after some kind of unrest. And that's what happens in the play. There is this rebellion of the bondmen, and then there are these pardons, and it's kind of suffused with the language of Stoicism and Stoic clemency, which was also a big concept at the time, where there was an idea that the just ruler should be a ruler who thought about kind of the general good rather than about his specific interests, and clemency and was part of that. So it wasn't exactly the same as pardoning, but it was this idea of the ruler with clemency who would be the most just ruler and would rule for the benefit of the state. So that's another play that I think is particularly interesting on this front.
So pardoning is a governmental and often a royal or executive thing. How does it relate to the more human practice of forgiveness?
Yeah, so I think the play that I mentioned earlier, The Laws of Candy, is really interesting in terms of sort of playing on that relation between forgiveness and pardoning, because what happens is that it culminates, rather than with pardons, with these interpersonal acts of forgiveness. So pardoning, as you're mentioning, kind of comes as a aspect of a sovereign power or sovereign prerogative, maybe it comes from above. It's forgiving a subject usually, or forgiving someone who's in your power, or pardoning someone in your power, rather than forgiving them. Forgiveness really ideally is from the person who's wronged. So forgiveness involves, some kind of letting go of a grievance that one justifiably has against another person. So I think that there's a much less institutional aspect of forgiveness, although the two concepts wind up kind of playing together in different ways. And then I think this also brings up the kind of religious aspect of pardoning as well as forgiveness, where James I, at least, sort of sees the role of the king's pardon as analogous to God's mercy, because God, in his mercy, is kind of forgiving sins on earth and allowing people to be saved, and that the king is similarly exercising a pardon power along the lines, or according to an analogy with divine mercy. So it has to do with his kind of theory of divine right, monarchy, and the role of that affects his exercise of the pardon power.
That makes more sense to me than something earlier about this being a judicial role, because judges don't really have a pardon power.
Yeah.
And so when the king does this, he's not really usurping the job of judges.
Yeah. Well, I think that the way that pardoning is conceived of in this moment is as a quasi-judicial power, because it's adjudicating a claim that subjects would have against each other otherwise. So it's thought of, because the judge is always someone who's coming in as a third party to adjudicate a claim between two others, there are ways in which the pardon power gets thought of along those lines. And of course, it doesn't necessarily have the same epistemological context, right? So that you don't have to necessarily base a pardon on knowing someone's guilt or not knowing it. But in terms of the adjudication of this claim that someone has against someone else who is, not you, I think that's where structurally there's a kind of similarity between, or that there's a similarity drawn between pardoning and judging.
And we have a comment. I don't know if this is a question or just an excellent observation, but from one of the audience members' comments, that also important is the unjust application of the laws, particularly when too zealous prosecution is involved.
Yeah, definitely. And I think that's something that kind of comes out in the context of this play Measure for Measure too, right? It's the sort of imposition of a law that seems unjust, but then also the person who's imposing the law, Angelo, is himself shown to be violating it. So it's the idea of the kind of hypocritical prosecutor imposing a law that they're not themselves following as well.
So time maybe for one more audience question. So this person points out that playwriting was a perilous profession in the 16th to 17th centuries. Ben Jonson and others went to jail for seditious plays. To what extent, if any, do you think the themes of pardoning emerge in these works during this period because of the potential criminal penalties imposed on playwrights by the crown?
Yeah, so I think that there's the genre of tragic comedy, and what I discovered in writing the book is that there are so many plays that fit this category of tragic comedy that ends with a pardon or pardons of some kind. But I think that this genre was exactly being used to kind of try out dangerous ideas without having real repercussions, right? So they're all ending comically. No one actually is executed. No one is actually harmed. So it becomes a way to call into question different, kind of moves of the state or different ideas that are circulating without having tragic repercussions. And certainly, it's often with tragedies that rulers wind up seeing themselves as the tragic hero or the tragic victim, and then deciding that the playwright is committing an offense. So I think that it was connected to this atmosphere of censorship and this the kind of grave consequences of writing something seditious.
Well, I see our time is up. That was a fast hour. Thank you so much, Bernie, for joining us this evening. And if we were in person, I would lead the audience in applause. And so I'll do that as best we can. And let me invite Morgan to tell everyone what our next event will be.
Yes, our next and final event of the year, can't even believe it, is a week from today, May 18th at 5 p.m. to 6:30. We'll be talking about social media's role in democracy, both the challenges and opportunities presented. We're convening 3 leading scholars in the field, David Kaye at UCI Law, who is the former special rapporteur at the UN on the promotion and protection of the right to freedom of opinion and expression. Also, Eric Goldman, the Associate Dean of Research and Professor of Law at Santa Clara University School of Law. And finally, Evelyn Dueck, an SJD candidate at Harvard Law School. I hope you can join us.
Thanks. And again, thank you for attending.
Michael.
And thank you, Bernie, for speaking. Good night to everyone.
Thank you.